In the criminal case, which is known as State versus Zaheer Ahmed and others, the child victim, who was an alleged victim of kidnapping, child marriage, and human trafficking, was transferred from Lahore to a shelter home in Karachi on the orders of the Sindh High Court back in July. And since then, the parents filed for visitation rights in the family court, through which they got to meet her twice a month, and which meetings have started from the 1st of November. And so far, I think they have met the child 5 or 6 times. And during those meetings, the child revealed her repeated desire to join and stay with her parents. Moreover, in a separate proceedings before the High Court, on our request, the court ordered that a psychiatric evaluation of the child be conducted, given what kind of stress or traumas she's suffering from. And in the report of those 2 doctors, one psychiatrist and one psychologist, they also submitted that the child is uncomfortable at the shelter home and she is expressing a desire to join her parents. Based on that, we filed a petition before the Honorable High Court, a habeas corpus petition, and said that and submitted that though her custody at the shelter home is not illegal because she was sent there on orders of the High Court, it is still improper because her education has come to a halt. Psychologically and physically, she's not comfortable over there, and because she doesn't have any grievances towards her parents and she wants to join them. Accordingly, the court had summoned the child today and to ask her consent in open court, which was done so, and the child very clearly told the court that she wants to stay and join her parents and her siblings. Accordingly, the Honorable High Court has directed that the custody be restored with the parents in the interim, and the final custody of the child would be decided eventually by the guardian and ward court, that is the family court where the matter is pending. And to ensure the welfare of the child, we ourselves offered that if the court so pleases, a child protection officer and a lady police officer can make weekly visits to the family and inquire upon the child's upkeep and update the trial court accordingly, which the court has also directed. And furthermore, we've been asked to furnish a bond in the sum of 1 million rupees, which we will also be doing. And hopefully now the child will be back in her home with her loved ones, and her education will resume, and so would her upbringing. In my own experience of cases I have done, this is the 3rd child which has returned from the shelter home to her parents after getting the time and the capacity and the space to think and ponder over their life decisions, and after being freed from the false fear and apprehension that their parents are angry and they want to avenge their honor, and they do not approve of the child having left the house, whether she was abducted or otherwise. And these kind of fears are, the child suffers from them because these kind of false fears are developed in the process of brainwashing by the abductors. And so once I think these things normalize and the meeting starts happening with the parents, and the child realizes that the parents are as understanding and as loving as they always were, and they also ponder over the life decisions, and they also are free from the clutches of the accused. So if any brainwashing or any blackmailing was taking place at the other end, or there was any threat of force or coercion, that is also gone. So over a period of time, these kids do decide to come back home. So I believe enough cases have happened, at least in my own experience in the past 2 years, for the Honorable High Courts now to develop a standard operating procedure that in such cases, rather than allowing the girl to leave with the abductor, the accused, it's better that minor girls should immediately be transferred to an appropriate facility maintained by the government or a private party, and where they are provided proper psychiatric evaluation, and they're allowed periodic meeting with the parents, and the child should be allowed to ponder over her decisions. And as it is, cohabitation with the girl, even under the facade of marriage, with an underage girl is illegal, because the Sindh Child Protection Authority Act 2011 sees child marriage as a form of child abuse, and states that whichever child in the province is suffering from abuse and is in need of special protection measures. So the law envisions that the child is to be protected from the abuser. So you cannot allow a cohabitation of a minor girl with a major male, even if a marriage has taken place. And the marriage itself is a crime as it is. So I hope, and one can only hope, that the courts on their own, showing some proactiveness, develop certain standard operating procedures, and some general strictures are passed, which was not so in our case, but I hope so it happens, so that a precedent is set and a kind of a template is ready for judges to follow in such cases.